Her hand finds the small of my back, palm flat, fingers spread, warm through silk. And I understand that she did not call me here to discuss procedural errors. My breath catches, audible in the silence of these chambers, in the amber light of late afternoon that turns everything slow and consequential. I feel it in the hollow of my sternum first, a low press of something that has no legal name, before it travels outward to the skin she is touching. Her mouth is close to my ear. Her voice arrives before I'm ready. You're going to stop apologizing now. Behind me, at some point I failed to track. The brass lock clicked into place. I did not hear it happen. That is the part I will remember longest. If you want to hear uncensored Too Hot for YouTube stories, check out my Patreon in the description. Tell us where you're watching from and subscribe. This morning I believed in federal court. I know how that sounds. Naive. But I had spent 8 months on state versus Morrison. 8 months of depositions and motions and weekend afternoons in my apartment with case law spread across every horizontal surface I owned. Building something I genuinely thought was airtight. I had color-coded tabs on my trial binder. I had a handwritten index card with my opening 3 sentences, not because I needed it, but because my supervisor at Harmon and Coyle had told me, back when I was still a second-year associate trying to get a real case, that the 3 sentences are what survive the nerves. I had practiced them in my bathroom mirror at 6:15 that morning until they felt like breathing. That was before I walked into courtroom 6D. I should say first that I have appeared before 11 judges in my 2 years since the bar. Some were lazy, some were sharp. One, in family court on the west side of the county, had actually fallen asleep during my closing and then woken abruptly to ask me to repeat the last thing I'd said, which had been the emotional centerpiece of everything I'd built. I had repeated it. He had nodded like he hadn't been asleep. I had gone home and eaten an entire sleeve of crackers and reconsidered my career. But none of them had been Vera Holt. The name had come up during case assignment. My supervisor, Diane Chen, had looked at the docket, looked at me, and said, "Federal Court, Judge Holt. You know her?" I did not. Look her up before you step in that room. She has a specific way of running proceedings, and attorneys who don't account for it don't survive it. I had looked her up. I had read her opinions on procedural issues, on evidentiary standards, on the specific brand of inefficiency she considered unacceptable from counsel. I had read a legal blog where 3 different attorneys described her courtroom as a place where you arrived prepared or you arrived humiliated. And those were the only 2 options available. I had thought, I will be prepared. I had color-coded my tabs. At 9:47 a.m. on a Thursday in November, I began my opening statement. I was 3 sentences in. I had gotten to the second sentence, the one about prosecutorial overreach, the one I had practiced in my bathroom mirror at 6:15, when she stopped me. Not for an objection from opposing counsel, not for a procedural violation that the record had caught before I did. For form, she said, "Counsel, stop." The room stopped with her. That was the first thing I noticed about Judge Vera Holt, that rooms obeyed her, not because they were afraid exactly, though there was that, but because her voice had a quality of such precise authority that the air itself seemed to understand compliance was the only rational option. The packed gallery went quiet in the particular way of people who sense they are watching something instructive happen to someone else. The court reporter's fingers lifted off the keys. The prosecutor, a man named Finley, who had been smirking at me since I walked in, went very still in the specific way of someone trying not to look delighted. I stopped. She was looking at me from the bench. I had seen photographs. The legal blog had included one, but photographs had not communicated the full fact of her. She was tall, even seated, or she produced the impression of height through something in her posture, the way she occupied the bench, as though it had always been specifically hers. The judicial robe was severe black against the wood of the bench, and the official seal mounted on the wall behind her. Her hair was pulled back in a tight, low bun, with a center part so precise it looked architectural, and 2 pieces framing her jaw with the exact calculation of someone who understood that severity and beauty did not have to be in opposition. Her eyes, from 20 feet across a courtroom, were dark and deep and completely without warmth in the way of someone who had long since decided that warmth in this specific setting was not a tool she intended to use. "Your argument structure," she said, "is built on a foundation that would collapse under any sustained pressure." You have led with the conclusion and buried the establishing evidence in a sequence that tells me you are more interested in sounding persuasive than in being logically unassailable. In federal court, those are not the same thing. I heard the gallery shift. Someone behind me coughed, which felt sympathetic in the way that coughs at concerts are sympathetic, acknowledging what is happening without involving themselves in it. I would ask you to start over, she said, but the problem is not your opening, it is your entire argumentative approach. You may sit down. I sat down. She did not say it cruelly. That was the thing that made it worse. She said it with the same measured precision she had used to say, "Stop," as though what she was doing was simply accurate, and accuracy was neither kind nor unkind, it was simply correct. As though dismantling me in front of a packed courtroom was a professional function, not a choice. She moved directly to Finley, who was already on his feet, and the session continued with the particular efficiency of a machine that has cleared a minor obstruction from its path. At 2:15 p.m., my client looked at me across the defense table, and I had nothing useful to say. Marcus Morrison was 37 years old and had made a series of specific poor decisions in a specific span of 6 months that a better attorney, a more experienced one who had perhaps walked into her courtroom once before and understood what the room required, might have reduced from 18 months to probation and community service. He was not a bad man. He had a daughter who had driven to the courthouse with his sister because she was 14 and couldn't drive herself, and I had met them in the lobby this morning before the session started, and the girl had said thank you for helping my dad in the earnest way of 14-year-olds who still believe that formal systems operate on sincerity. I had told her that I would do my best. I had done my best. Judge Holt had found it insufficient. By 4:30, the courthouse was emptying in the specific way of government buildings at end of business day, that particular relief of marble corridors filling with the sound of a day concluding. I was at the defense table packing my trial binder, which felt like wrapping up evidence of something I would not want to examine again for several days. My legal pad had 3 pages of notes I had not used because the session had not developed the way I had planned for it to develop. My color-coded tabs were intact. They seemed like a commentary on something. The bailiff appeared beside me. He had the look of a man who had delivered variations of this particular message before. "Judge Holt wants to see you in chambers." I stood up. I cannot tell you what I was expecting. Something bureaucratic, probably. Some formal clarification of procedural requirements, some official framework for what had happened and what would need to happen differently going forward. I was not expecting anything that deviated from the official record of the day, which was, an attorney had appeared in her courtroom and been found insufficient and had lost a case she had spent 8 months preparing for. That was the record. Chambers would be an annotation. I gathered the trial binder in my bag and followed him down the marble corridor. My heels sounded very loud on the stone floors. The building had that after-hours quality it develops when the public-facing performance of justice wraps up for the day, something quieter and more institutional. The hum of fluorescent lights in empty offices, a distant elevator bell, the particular quality of echoes when a space empties out. My reflection moved through the glass of office partitions as I passed them, and I looked in that reflection like someone who had been outside in weather. Professional but disarranged at the edges in some way I couldn't precisely locate. The bailiff stopped at a door with a frosted glass panel. Knocked twice, a quick professional knock. Opened it without waiting for a response in the specific way of someone who understood the protocol. He stepped aside. I went in. She was behind the desk, still in her robe. The window behind her desk faced west, and the late afternoon sun had gone to that particular golden hour quality that makes silhouettes out of things you want to see clearly, and she was standing exactly in front of it, so that I was looking at the shape of her against the light. Tall, composed, completely unreadable. The overhead fluorescents were off. The desk lamp with its green glass shade cast a pool of warm amber on the desk surface, and everything beyond that pool graduated into shadow. The rest of the room arranged itself around her, the floor-to-ceiling bookshelves packed with legal volumes creating walls within walls, the 2 formal leather chairs positioned in front of the desk like they were also waiting for instructions, a small consultation table in the far corner with 2 chairs at a right angle to each other that suggested a different category of meeting entirely. The door closed behind me. She did not speak. She did not gesture to the chairs. She simply looked at me with the same quality of attention she had used in the courtroom, the kind that did not require her to say anything to produce an effect. A gaze that was a physical event with a specific location, and the location was somewhere in my chest, just below my sternum, where it applied a slow, deliberate pressure. I held it for as long as I could manage. Then I looked away. We both knew what that meant. "Lock it," she said. I turned. The brass mechanism was old, the kind of courthouse hardware that has operated for decades with the particular reliability of things made before planned obsolescence. I put my hand on it. My hand was shaking slightly, which I noted with the detached observation of someone cataloging evidence against herself. The lock turned. The click it made was final in the specific way of mechanisms that have done this before and know what it means. I faced her again. She had moved. She was no longer behind the desk, but standing beside it, one hand resting on the case file, State versus Morrison, my color-coded tabs visible from across the room, with the stillness of someone who has learned to make stillness do the work of entire sentences. She had taken off her reading glasses. In the amber light from the desk lamp, I could see the edge of her jaw properly for the first time, the sharp architecture of her face, without the distance of the courtroom between us. The robe was still on. There was something about that, the continued presence of the official garment in this unofficial moment, that produced a tension I didn't have immediate language for. "You're angry," she said. Not a question. An observation offered with the same clinical precision she had applied to my argument structure 8 hours earlier. I was. That was accurate. I was furious in the particular way of someone who had been right and wrong simultaneously. Right about the work I had put in. Wrong about whether it would be enough. And with the specific anger of someone who cannot be angry at the right target, because the right target is standing 3 feet away and holds every structural advantage in this conversation. I was angry at her, and at myself, and at the specific public quality of what had happened. A room full of people, colleagues and strangers, and a prosecutor named Finley who had been smirking since 9:47, all of them witnesses to the precise vocabulary she had used to reduce 8 months of preparation to a logistical problem she had noted and moved past. I started. "Don't!" She moved. One step from the side of the desk, slow and deliberate. "Don't apologize. Don't explain. Don't do whatever you've been taught to do when someone with authority corners you and expects you to make it easier for everyone." She took another step. She moved the way she ran proceedings, with the specific economy of someone for whom every action has been considered and the unnecessary ones have been quietly removed. Each step closed distance with a precision that felt calculated, and yet there was something in the quality of her breathing that was not fully controlled. Something almost imperceptible. I filed it away. "You want to know why I called you here?" Still not a question. Another observation. I nodded. She was 3 feet from me now, close enough that I could see things the courtroom hadn't allowed, the faint shadows under her eyes that suggested she slept less than she projected, the way the tight bun had loosened fractionally at one temple over the course of the day, a single strand of black hair resting against her jaw that she had not corrected. The composure was intact, but it was also, I now saw, constructed, which is different from natural. Natural composure does not require maintenance. Constructed composure does, and the maintenance is just barely visible if you're standing close enough and paying the right kind of attention. The desk lamp threw its amber light between us. I could smell her perfume at this distance, cedar and something cooler underneath it, like cold linen or stone, a scent that was austere and specific in the same way she was austere and specific, that did not make concessions to approachability. I noted this information and filed it in the wrong drawer. She reached past me. My body registered it before my mind could interpret the geometry. A reach past me, toward the door, toward dismissal. Some formal conclusion to this formal meeting. My muscles had already begun to configure for that outcome. Already begun the small adjustments of someone accepting a meeting's end. Her hand found the small of my back, palm flat, fingers spread. The warmth of it arrived through the silk of my ivory blouse, and it was warmer than I had expected. Considerably warmer than the controlled temperature of everything she projected, and it was present in a way that was impossible to categorize as accidental or professional or anything with a label that would hold. My breath caught. I heard it happen. I heard myself make the audible, involuntary evidence of a body responding before the mind has had time to compose a position. Hers didn't change. There was a precision to that, the fact that hers didn't change while mine demonstrably had, that told me something I had not been looking for. She was aware of what she was doing. She had known what it would produce. She was not surprised by my reaction because she had anticipated it, which meant she had thought about it, which meant she had, at some point prior to this moment, considered what her palm flat against the small of my back through silk would do to my capacity to function, and had arrived at this moment having considered that. Her thumb moved, one small circle, against my spine just above the waistband of my navy pencil skirt. One circle, contained and precise, like punctuation on a sentence I hadn't heard the beginning of. Something happened to my knees. I noted this medically, the way you note a symptom. The particular softening at the joint, the small, unreliable quality that my knees had not had before, that arrived specifically in response to one thumb moving in one small circle against approximately 2 inches of my spine. I noted it and did not move because moving felt like acknowledging it, and I was not yet prepared to acknowledge it. Her mouth was very close to my ear. I had not heard her lean in. The approach had been too quiet, too considered, too precisely calibrated to arrive without announcement. Her breath was warm against the curve of my ear and the side of my neck, and I felt it on the skin there the way you feel something that travels faster than explanation, before the language that would frame it has arrived. I called you here, she said, because watching you lose was the hardest thing I have done from that bench in 3 years, and I needed you to know that before you left this building believing I was something I'm not. The word hardest dropped half an octave. I heard it happen. The register shift was subtle, a fraction of a step down, the kind of change that might not be audible to someone not paying the specific quality of attention that I was paying. But I was paying it, and I heard it, and simultaneously, the hand at the small of my back pressed slightly more. Not dramatically, not with the quality of a gesture, but with the incremental quality of something forgetting to maintain its own careful calibration. A thumb that had been precise and deliberate, and considered now pressed with the additional weight of something that had slipped slightly past deliberate into somewhere else. I stood very still. In 8 months of preparing for State versus Morrison, I had constructed a number of theories about what could happen in a courthouse. A judge summoning me to chambers after a loss was not outside my working assumptions. A judge who ran proceedings the way Judge Holt ran them, issuing some formal correction or additional guidance. That was within the parameters of what I had prepared for. What was not within those parameters, what I had no tab for in my color-coded trial binder, was this. The most frightening woman in the courtroom had her palm flat against the small of my back in the amber light of her private office, and was telling me in a voice that had lost half an octave that watching me lose had cost her something. I was not prepared for that. My body had already decided how it felt about it. The cedar and cold linen scent was closer now, filling the specific quality of air between us that was very small, the kind of space that is measured in inches rather than feet, that requires a particular kind of awareness to navigate without contact. I could hear the silence of the building around us, the distant hum of a corridor, the far elevator bell, and inside these chambers, nothing except our breathing and the occasional sound of fabric settling, and the particular silence of the case file on the desk between us that I had stopped caring about at some point in the last 4 minutes. I could feel my own heartbeat. It was not behaving. The amber light from the desk lamp made everything warm and slow and particular, the way late afternoon light does when it has stopped being general and has become specific. Directed at this room, at this desk, at the 2 inches of my spine where her thumb had made one small circle and not moved since. My trial binder was clutched against my chest. I realized, holding it with both hands in the way of someone who has decided it is a structural component of their composure. Which meant it was doing work it had not been designed for. She still hadn't moved away. Neither had I. The distance between us was the specific geometry of aftermath, not the clean distance of beginning, but the complicated close distance of something that has already happened and cannot be technically unhappened. Her hand was still at the small of my back. The warmth of her palm had stopped feeling like something she was doing and had started feeling like something my skin had accepted as a condition of the room, the way you stop noticing temperature when you've been in it long enough. Except I was very much still noticing. The pen on the desk rolled to the edge, hit the carpet with a soft sound. Neither of us looked at it. She didn't step back. I should have. The correct move, the professionally defensible move, the move that my 2 years post-bar and my 8 months of preparation and my color-coded trial binder and my bathroom mirror practice at 6:15 in the morning had all trained me toward was to step back, to reconstitute the appropriate distance, to say something measured and appreciative about the clarification she had offered regarding her ruling, and to gather my binder and my bag and my professional dignity and proceed through the locked door out into the marble corridor. I did not do any of that. Her other hand came up slowly enough that I was aware of its entire approach, could track the trajectory from beside her body to the air near my face, could register each second of the approach as a second during which I had the option to move, and did not take it. Her fingers found my jaw, not gripping, not forcing. The contact was the precise opposite of force. It was a question asked entirely through the geometry of fingertips and jawbone, directing my face toward hers in the way of someone who expects the answer they are asking for. I turned. I was looking at her now. At the full fact of her at this distance, which was entirely different from the fact of her at 20 feet across a courtroom. At this distance, I could see the specific quality of her eyes. Dark, yes, but with a depth that was not flat or opaque, but complex in the way of things that have thought and feeling layered behind their surface, that are doing considerable internal work that the surface has been instructed not to transmit. At this distance, I could see that the composure was costing her something. It had been easier to miss from across the room. "Tell me to stop." Her gaze dropped to my mouth. A brief but complete drop, the kind that registers as a physical event in its own right. "Tell me this isn't what you came here hoping I'd do." I could not tell her that. I had walked into this building this morning with color-coded tabs and bathroom mirror practice and the particular certainty of someone who is prepared enough to feel ready. I had spent the day being systematically dismantled by a woman I had not had the vocabulary for until now. I had packed my failure into my trial binder and been summoned to this room, and I had known somewhere in the part of me that processes information before the mind composes a narrative around it, that I was walking towards something that had nothing to do with procedural clarification. My voice was not at full capacity. I didn't know I wanted. Yes, you did. Her thumb moved to my lower lip, the pad of her thumb. A single slow trace across the lower curve of it, and my lip registered this with the complete specificity of skin that has been waiting for something without knowing it was waiting. "You changed your blouse between this morning and court resuming. Put on something softer. You weren't planning to go home and grieve into your trial notes." She was right. I had gone to the bathroom at the noon recess and done something I had not planned to do, which was to take off my morning blouse, a sensible navy that matched my suit, the appropriate, professional, invisible blouse of someone who is there to argue a case, and replace it with the ivory silk I had packed in my bag without, I had told myself, any particular intention. The ivory silk was softer. It moved differently. It had a different relationship with light. I had told myself in the courthouse bathroom mirror with the fluorescence overhead and the sounds of the building around me that I was doing this to recalibrate, to feel different, to approach the afternoon with a different sense of myself. I had not told myself the other thing. The blush lace bralette I had put on that morning, the third one I had tried, the one I had settled on after standing in front of my closet for 11 minutes telling myself I was making a practical decision about comfort, was just barely visible at the neckline of the ivory silk if you were paying attention. If you were close enough, if you were looking. She had noticed. "You wore this," she said, "for me." The end of the sentence landed with the particular quality of conclusions reached by someone who does not announce preliminary findings, who goes directly to the verdict. Not consciously, maybe, but you did. Her eyes darkened. Not metaphorically, there was an actual physical change in them, some deepening of the dark that was also a change in the quality of her attention. A shift from assessment to something that had no professional category. Her hand slid from my jaw to the back of my neck. Fingers in my hair, the honey blonde waves loose from the morning, having given up on the professional arrangement somewhere around the lunch recess, and her thumb pressed against my pulse point. I felt my own heartbeat transmitted through her thumb. I thought, that is information she now has that I did not intend to give her. She made a sound, low, almost at the threshold of audible, not quite a breath and not quite something else, not quite a word. When her thumb registered the speed of my pulse, the sound came. Involuntary, in the specific way of sounds that arrive before the person producing them has decided to produce them. Not a laugh, not satisfaction, something that contained both of those and underneath them something rawer, something that sounded, if I was naming it accurately, like relief, like finding confirmation of something she had been uncertain about. Her eyes closed. 2 seconds. Her jaw tightened slightly, the muscle at the hinge of her jaw visible for a moment as she held something. She looked like a person standing at the edge of a decision they have already made but have not yet allowed themselves to make. Like someone trying to hold on to a last grip on the thing they have already let go. When she opened her eyes, her hand tightened in my hair. Her fingers pressed against my pulse point, and my heartbeat pressed back, and there was something between us that was the specific pressure of two things that have been maintained at distance by deliberate effort, that are now close enough that the effort required to maintain the distance has exceeded what is available. The case file was on the desk beside us. State versus Morrison. my client and my failure in 8 months of work, present and completely irrelevant. The gavel was visible on the desk, the courtroom authority symbol sitting there with the particular irrelevance of objects that belonged to a different context than the one currently in use. The overhead fluorescents were still off. The desk lamp continued to produce its pool of amber. Outside the west-facing window, the late afternoon had turned the courthouse plaza 3 stories below the specific gold of day, concluding. Inside chambers, the silence was of the pressurized variety. "Come here." Her voice had gone to a register I had not heard in the courtroom. Lower, rougher, with less of the architectural control that made her courtroom voice function as a force of nature. Not a request, but also, I noticed, not quite the commanding tone of the bench. Something between those 2 registers, something that was authority and something else together, something that the authority was now sharing space with. She guided me. Not forcibly. Her hand at the back of my neck did not grip or push. The guidance was minimal, the smallest possible amount of physical information, and my body responded to it with a completeness that told me the body had been waiting to respond. 3 steps backward until the backs of my thighs found the edge of her desk. The trial binder was somewhere behind me, the legal pad, the remnants of preparation for a case that was already concluded. I was against the desk. She stood in front of me, not caging. There was space on both sides of her, the possibility of movement present and available and not taken by either of us. Just close. Just the specific proximity of standing in front of someone and choosing not to retreat on both sides simultaneously. Both of her hands found my hips. The warmth of them arrived through the navy pencil skirt and the blouse tucked into it, palms full against the swell of my hips with her thumbs pressing just below my ribs, fingers curving around toward the small of my back. And at this point, the small of my back had become a place with a different kind of significance than it had when I had walked into this building this morning. My body cataloged the pressure of her thumbs below my ribs with the specificity of something being written in. Not noted, written. "Tell me what you want." She had the voice she ran proceedings with, the one that did not entertain alternatives to compliance, but there was something happening to it now. A roughness under the precision, the specific roughness of a surface that has been maintained at control and is costing that maintenance more than it recently did. Less controlled. Deliberately less controlled in the specific way of a choice. I couldn't finish. My mind was doing the thinking in practical, unglamorous terms that it usually did, cataloging the situation with the dry, self-directed accuracy that got me through difficult depositions and difficult mornings, and the particular difficulty of standing in a courtroom being reduced by someone I was already paying an inadmissible level of attention to. What it was cataloging now was her thumbs below my ribs, her palms at my hips, the cedar and cold linen scent of her at the specific distance of nearly no distance, the sound of my own breathing which was not fully cooperating, and the way my back wanted to arc toward her without my permission. "Yes, you do." She leaned in. Her mouth found my throat. Not a kiss, not quite a kiss, just lips barely parting against the skin at the hollow of my neck where my pulse was doing its loudest work, and she breathed there. Warm and deliberate and present, her breath against my skin at that specific location, and it traveled from the surface of my skin inward with a speed and directness that bypassed every system I had in place for processing sensation through appropriate channels. "You've known since the first time you walked into my courtroom 3 months ago, and I couldn't look at you the way a judge should look at an attorney who appears before her bench." 3 months ago, the motion hearing, the preliminary proceeding I had attended in September, a brief appearance before the case was fully assigned to argue a single evidentiary point. I had been in her courtroom for 40 minutes. I had thought about it afterward, in the particular way of thinking about something that you decide not to examine too closely, as a reminder that the case was federal, and the stakes were specific, and the judge was formidable, and I would need to prepare accordingly. I had not thought about it in any other category. She had apparently been thinking about it in another category. Her body was a wall between me and the rest of the room. The rest of the room had become conceptual. The bookshelves, the consultation table in the corner with its 2 chairs at a right angle to each other, the frosted glass panel in the door with its brass lock engaged. The desk behind me was solid and real, and the legal evidence of this session's conclusion was somewhere on its surface. And none of that had weight in comparison to the weight of her hands at my hips and her breath against my throat, and the specific quality of the silence around us that was not empty, but dense, pressurized, full of all the things that had not yet been said aloud. I was wearing too many layers. I reached for the button of my navy jacket. Her hand covered mine. Let me. 2 words. Her hand on mine, still, not moving, waiting for the fraction of a second during which my response would become legible. I did not pull away. I did not speak. My hand was still under hers, and neither of us moved, and the moment balanced there with the specific weight of moments that have no neutral outcome, the ones that cannot be left without consequence in either direction. Then she moved. The first button. Slow, certain, not hesitant, not asking for confirmation at each step, but performing the action with the precise deliberateness of someone who has decided and is now executing the decision. The second. The third. Her knuckles grazed the silk of my blouse at each button, and the graze was incidental and produced a response in my skin that was not incidental at all. She worked in silence. No sound in the room except the building's distant hum and the quality of our breathing and the particular sound of a well-tailored jacket opening. She slid it off my shoulders. I felt the cool air of the room arrive against my upper arms as the jacket went. She held it for a moment. I wasn't looking at her. I was looking at the middle distance over her shoulder at the law volumes ranked on the shelves. And then it fell. I heard it land on the carpet behind me. She went very still. I looked at her. She was looking at the ivory silk blouse. At the way it moved, the soft drape of it in the amber light, the specific quality it had of suggesting rather than stating. And at the edge of the blush lace bralette, visible just above the neckline. The third one I'd tried that morning, the one I'd chosen because it was softer, because it was less practical, because it was the choice I had made in front of my closet at 6:15, while I was also telling myself I was making a practical decision about comfort. She looked at me the way a court looks at evidence that confirms what it suspected. Her finger found the edge of the lace above my collar. Just one finger. The tip of her index finger tracing the scalloped edge of the blush lace where it showed above the silk with a precision that was not accidental and was not general. It was addressed to that specific 2 inches of visible lace, as specifically as her evidentiary objections had been addressed to specific flaws in my argument structure this morning, tracing it once from one end to the other, then lower, following the button placket of the blouse down, fingertip against the silk, the line of buttons I had changed into at noon recess in a courthouse bathroom in front of a mirror while the fluorescents hummed overhead. You wore this for me. Her voice had the quality of a ruling from which there is no further appeal. Not a question. A verdict delivered with the complete certainty of someone who does not announce preliminary findings. Not because you knew this would happen, but because somewhere in you you were hoping it might. I did not deny it. The denial would have been technically plausible. I could have constructed an argument for it, found the supporting evidence, made a case. I had spent 8 months making cases. I was, by professional definition, someone who made cases. But she was looking at me with the dark eyes and the specific quality of attention that had followed me since September, that had occupied a drawer in my mental filing system that I had labeled incorrectly and hadn't corrected. And the truth was, she was right, and I had known it since approximately noon when I had chosen the ivory silk in a bathroom mirror and told myself a story about recalibration. Her eyes changed, something deepened. A shift in the quality of the dark, a change in the composition of her attention that moved from assessment to something that had no designation in any legal category I was trained in. Something that was warmer than assessment and rawer than professional interest, and that had been, I now understood, present since September in a drawer I had mislabeled. Her hand slid from the button placket to my jaw again, and from my jaw to the back of my neck, fingers moving through the loose, honey-blonde waves with the quality of something that had been withheld and was no longer being withheld. A touch that was not the first touch, but was the first honest one. Her thumb pressed against my pulse point. My heartbeat gave her everything. She closed her eyes. The jaw muscle tightened. Visible, a specific physical evidence of cost, of what it required to hold something that was already past holding. 1 second. 2. The room was absolutely silent around us in the way of rooms that have stopped being settings and have become chambers, sealed, amber-lit, separate from the marble corridors and the empty courtroom and the elevator bells that marked the progress of everyone else's day. When she opened her eyes, her hand tightened in my hair. The sound she made was not loud. It was the opposite of loud. It was the specific sound that exists just below the threshold of deliberate sound, the sound of something that has been held back, reaching the limit of what holding back can accomplish. I felt it in the side of my neck, where her breath was warm and her lips were barely there, barely grazing, barely distinguishable from breathing. But she was not just breathing. She was deciding. I knew the quality of that pause. I had spent a day watching her decide things, watching her assess and conclude and rule, and this was the same quality of pause with an entirely different content. This was the pause at the end of a long and considered deliberation. The verdict was in. She was deciding whether to read it aloud. My hands were at my sides. My trial binder was somewhere behind me on the desk, and my jacket was on the floor, and the case file was under everything, and none of it mattered in the amber light of late afternoon chambers with cedar and cold linen filling the small and pressurized air between us and her hand, in my hair, and her thumb at my pulse, and the sound of my own breathing, which had stopped being a passive function and had become something I was doing consciously, deliberately, one careful breath at a time. Her other hand was still at my hip. Her thumb pressed below my rib, a small and certain pressure, and the contact traveled from that specific anatomical location, the soft flesh just below the rib's lower edge, a location I had never particularly registered before, directly to some central organizing system I had apparently been protecting without knowing I was protecting it. And what arrived there was not warmth, exactly, but something that incorporated warmth and recognition, and the specific feeling of a lock turning over in something that had been locked a long time. I reached up. My hands found her shoulders, the black judicial robe still on, the fabric of official authority that had been present all day as evidence of the distance between us, solid under my hands, real. I could feel the shape of her through it, the lean, composed structure of her, the height of her more present, now that there was no desk between us and no 20 feet of courtroom and no official spatial arrangement requiring us to be in our respective positions. She pulled back half a measure. Not away, not a retreat. A re-examination. She looked at me, full and complete, and at the closest distance we had been. And I was aware of being fully seen in the way that you are aware when someone's attention is so specific and so complete that there is no angle you are not being seen from. The warm, fair skin of my face, and the rosy cheeks I had tried to manage with foundation this morning, and the honey blonde waves that had long since given up their morning arrangement, and the ivory silk, and the blush lace, and the eyes that were not, I suspected, doing anything in this moment that they had not been doing since September. She looked like someone who has arrived at the conclusion of a long deliberation and is taking one final inventory before the verdict. Then she moved her hands, both of them, from my hip and from my hair to the buttons of my ivory silk blouse. She did not ask. She had passed the point of asking. The first button came open with the particular deliberateness of someone who is choosing the speed they are moving at, who is making the slowness into a statement. The second. Her knuckles grazed my skin through the gap in the blouse as each button released, and the graze was warmer than her hand had been, the specific warmth of skin against skin where the blouse had separated, and my own skin registered each graze as a separate and complete event. Third button. Fourth. She pressed the silk open, let it fall from my shoulders to pool on the desk behind me, and went very still, the blush lace bralette in the amber light. The soft, warm skin of my sternum and ribs and the upper curve of my chest visible above the lace. Breathing too fast to make any pretense of composure. The rosy flush that had moved from my cheeks to my throat to the skin visible above the lace in a progression that had nothing to do with temperature and everything to do with the fact that this woman, who had dismantled me in a packed courtroom at 9:47 this morning, was standing in front of me in her judicial robe in the amber light of late afternoon, with her hands open at her sides and her eyes doing something I had no professional category for. "You planned this." Her voice was wrecked. It was the only word that was accurate. Wrecked in the specific way of something that has been maintained at enormous effort and has now arrived at the end of what that effort can accomplish. The courtroom authority was gone. The precise register, the architectural control, the voice that stopped rooms, all of it gone, replaced by something rawer and lower and completely without the distance that had been between us all day. Everything this morning, changing, walking in here. "You planned this. I had not planned it." I had packed the ivory silk in my bag on a Tuesday evening while telling myself it was because I had a long day ahead and wanted options. I had put on the blush lace bralette on a Thursday morning while standing in front of my closet for 11 minutes telling myself I was making a practical decision. I had changed at noon in a courthouse bathroom and told myself it was recalibration. I had walked into these chambers telling myself it was professional obligation. I had not planned it. I had done something more consequential than planning, which was to allow a series of decisions that were not fully examined to accumulate into an arrival. And here I was, arrived. I nodded. She made a decision. I watched it happen in the specific way that decisions look when they are made by someone who makes them rarely and completely. Not a gradual softening, not a slow dissolution, but a moment of resolution that was itself a kind of choosing. Her expression changed in the specific way of a face allowing itself to change, the muscles releasing something they had been holding since I walked in, or possibly since September. And then she was against me. Her mouth found mine, and it was not gentle. It was not tentative. It was the exact opposite of the courtroom voice, direct, certain, without the management of distance that had characterized every other interaction between us. Her hand came to the back of my neck, fingers curling into the hair at the nape, and the other hand slid inside the open blouse, the ivory silk hanging loose at my sides, to rest against my ribs. Her palm was warm, considerably warmer than it had been when she pressed it against the small of my back through silk, because now it was against skin, and skin registers everything differently. My hands found her shoulders, moved to her hair, the tight low bun, the severe center part, the architectural decision she made every morning about how she would present herself to rooms. And I found the pins, and they were not many, and they came loose, and the black hair that had been a vertical line of severity all day fell and was not severe at all. And she made a sound against my mouth that I felt in the lower part of my sternum. Her hand slid from my ribs to my waist, fingers pressing into skin with a certainty that was itself a form of statement. This, here, you, now. My back arched. This was involuntary. My body was operating on its own assessment of the situation, had apparently been conducting that assessment for longer than I had been paying attention to it, and was now acting accordingly. She pulled back, half a breath's worth of distance. Her forehead came to mine, the exact geometry of that, the specific contact of her forehead against mine in the amber light, with her hair loose and her voice wrecked and her hands at my waist. And we were both breathing hard, and it was entirely audible in the absolute silence of sealed chambers. And she was looking at me from the distance of no distance at all, and her eyes had the quality of the deep water in the dream version of somewhere you have wanted to be. Her thumb moved against the underside of my breast through the blush lace. One slow and deliberate movement, and my body responded to it as though it had been waiting for exactly that motion, in exactly that location, with the patience of something that has no other operating purpose. Which was not accurate. I had other operating purposes. I was a criminal defense attorney who had spent 8 months preparing for a federal case. I had color-coded tabs, but in this moment was experientially true. The sound I made was not quiet. She looked at me, at the sound I had made, at the warm, fair skin flushed to rose above the blush lace, at the honey-blonde waves disordered now around my face, and her hands at my waist, and the whole assembled evidence of where the day had arrived from where it had begun. She kissed me again, slower this time, deeper in the way of things that have stopped rushing, because the rushing was an artifact of uncertainty, and the uncertainty has been resolved. Her hands were at my waist and mine were in her hair, and the amber light from the desk lamp was everything we had for illumination, and it was sufficient. It was exactly sufficient. It made everything the color of something that does not need explanation. The case file was on the floor somewhere. I did not know when it had moved there. The trial binder was somewhere nearby, my legal pad. The evidence of preparation for a case that was concluded, present but comprehensively irrelevant. The lock on the door held. I understood, in the amber light with her forehead against mine, and her hands at my waist, and the black hair loose against her jaw where the severe bun had been all morning, that the lock had never been about keeping the corridor out. It had been about keeping us from the option of leaving before this became undeniable. Before we arrived at the conclusion of the deliberation she had been conducting since September, and I had been misfiling since September, and that had produced this. The small of my back through silk at the start, and then no silk, and then no distance, and the specific sound of a brass mechanism engaging that had been. I understood now, in the way you understand things when you are past the need to explain them. The only verdict that the evidence had ever been capable of producing. Her thumb pressed once against my pulse point. I did not move. I did not breathe. She felt my heartbeat, and her expression did the thing it had done twice before. The jaw tightening, the cost visible in the muscle, the face of someone holding something that has become too much to hold. But this time she didn't close her eyes. She looked at me. She held the look, and she held me at the waist, and she let everything the day had built arrive fully between us in the amber quiet of these chambers. And it cost her something I could see precisely and could not name, and she allowed it. She was choosing to let it cost her. That was the thing I would carry out of this room, not the moment itself, not the kiss or the amber light or the cedar and cold linen of her that I had been storing in the wrong drawer since September. The thing I would carry was the quality of her choice, that she had not lost control. She had located the door in the middle of all that architectural composure, and she had opened it, carefully, intentionally, and stepped through, that she had let me see her do it. We did not speak for a long time after. She stepped back slowly. I felt the absence of her hands at my waist in the specific anatomical location of her hands at my waist. The warm pressure gone, and the skin there registering the absence the way skin registers something it had accepted as a condition, and now must recalibrate without. Her hand slid away with a reluctance that was not demonstrated, but was present in the slowness, in the way the palms did not lift, but slid, as though maintaining contact as long as the geometry allowed. She watched while I buttoned my blouse. My hands were not steady. This was visible. She watched it with the quality of attention that was different now from the courtroom attention. Still precise, still complete, but with something beneath the precision that was neither cold nor clinical. Something that had emerged from wherever she kept things she did not bring to the bench. 3 buttons. 4. The ivory silk closed. I was aware of how I looked. Flushed, hair disordered, the precise professional presentation I had assembled at 6:15 this morning entirely reconstituted into something else. Something softer and more honest and less defensible in any official proceeding. She moved, bent and picked up my navy jacket from the floor, held it open. I put my arms through. Her hands came to my collar, both of them adjusting the lapels with the same precision she brought to everything. Her fingers at the fabric near my throat, straightening the line of it until the jacket sat correctly on my shoulders. Her hands lingered, not dramatically, just a fraction of a second beyond the completion of the adjustment. A fraction of a second in which her fingers were at my collar and the amber light was between us and we were both entirely still. "This doesn't leave this room," she said. Her voice had begun to reconstruct some of its surface, the way water settles after disruption. Not the same as before, the surface altered by what had moved through it, but tending toward composure again. "Not because I'm ashamed, because you deserve better than becoming a footnote in something that should be the whole story." I looked at her. She was looking back. And in the quality of her looking, I could see what she was not saying, which was the same thing I was not saying, which was, "This has a continuation. It has a continuation, and neither of us is going to name it tonight, and both of us know that naming it is simply a deferral, not an absence. Because things that have been building since September and have finally arrived at where they were always going do not tend to require naming." I nodded. She moved to the door. The brass lock, old mechanism, distinct sound. She turned it, and the click it made this time had a different quality than the click that had sealed us in. That one had been final. This one was the kind of sound that belongs to the opening of something, to the mechanism of continuation. She held the door open. I gathered my trial binder from the desk, the color-coded tabs, the case file that was already concluded, my legal pad with its 3 pages of unused notes, my bag from the chair by the door. All the material evidence of who I had been when I walked in, which was not precisely who I was walking out, though the inventory was identical. I moved toward the door. The corridor was there, the marble, the distant hum of the building's night functions beginning, the overhead fluorescence of the hallway that had none of the amber specificity of chambers. The ordinary world, the world in which this had not happened, in which this day was a professional loss and a summoning and a formal clarification that had resolved something. I passed her in the doorway. Close enough that the cedar and cold linen arrived one final time at the distance of passing, and my body registered it in the specific location it had been registering it all afternoon, which was the small and particular area of skin at the small of my back where her palm had pressed through silk, warm and certain, the first time. That location had not resumed its former indifference. I did not expect it would. "Mara," I stopped. One step into the corridor, marble under my heels, the trial binder against my chest. My name in her voice, which was still rougher than the courtroom voice, still carrying the evidence of what the afternoon had cost it, and what it had produced. I looked back. She was in the doorway, backlit again from the amber light of chambers, silhouetted the way she had been when I first walked in. shape and height, and the quality of her presence that had nothing to do with the judicial robe or the bench or the official seal. But she was braced against the doorframe now, one hand against the wood, the weight of her leaning slightly into it, and that was not how she had been standing when I walked in. That was not the composed architecture of authority. That was a person who needed the support of the frame. I looked at the hand on the wood. Same time tomorrow. Her voice had recovered enough of its courtroom register to deliver the words with the quality of a ruling, not a request, a sentence handed down. I did not answer. I turned and walked. Down the marble corridor, my heels sounding the way they had sounded on the way in, but differently. Or I was hearing them differently, which amounts to the same thing. Past the frosted glass doors of empty offices. Past the elevator bank where a distant bell marked someone else's descent. Past the doorway to courtroom 6D, which was dark inside and empty in the specific way of rooms that have done their work for the day. I stopped outside it for a moment. The gallery where people had been sitting this morning was invisible in the dark, but I knew the arrangement, the packed rows, the bailiff's position, the prosecutor's table where Finley had been smirking, the defense table where I had sat down when she told me to sit down after 3 sentences of an opening I had practiced in a bathroom mirror at 6:15, the bench where she had been, the bench she ran from, the way she ran everything, with complete precision and the absolute authority of someone who understood that rooms obey you if you understand how rooms work. I had walked into that room this morning believing I was prepared. I had been correct, and I had been incorrect, and the part I had been incorrect about was not the part I had expected. I walked on, through the lobby, past the security station, shut down for the evening, the metal detector that I had passed through this morning with my trial binder on the belt, my heels and my color-coded tabs and my bathroom mirror practice. Out through the heavy federal courthouse doors into the evening. The courthouse plaza was empty. 3 stories below the window of her chambers, which were above me and to the left, the amber light still visible against the gathering dark. The plaza stone was cold-looking in the way of public spaces in late afternoon, all the warmth of the day having relocated somewhere private. I stood there for a moment, my trial binder against my chest, the case that was concluded, the ivory silk under the navy jacket under the early evening air, the specific 2 inches of skin at the small of my back, which had not resumed its former indifference, and which I did not expect to resume it in the near future. My pulse, still not behaving. The brass lock had clicked into place. I had not noticed when. I had been standing in her chambers with my hand already reaching for the lock before she told me to lock it, which was interesting information about who I had been when I walked in and what I had already, in some chamber of myself I had not been consulting, decided. The lock had not been about keeping the corridor out. It had been about keeping us from the available exits before the evidence had fully arrived, before the verdict was in, before the deliberation that had been running since September had reached its natural conclusion. I had planned this, not consciously, not with color-coded tabs and bathroom mirror practice, and the particular certainty of someone who is prepared enough to feel ready. I had planned it the way the body plans things, in the accumulation of small decisions made from a center that does not use language, that had been making its assessments since September and had been arriving, quietly and without announcing itself, at a conclusion. The ivory silk, the blush lace, the noon recess bathroom, the way I had walked into these chambers with my trial binder against my chest like a shield that had already failed, the way my hand had been on the lock before she told me to turn it. I had not lost today. I had walked into her courtroom 3 months ago, and she had seen me, and she had spent 3 months not doing this, and today she had stopped not doing it, and that was a different category of outcome than the one I had been tracking on my legal pad. I looked up at the courthouse. The amber light in the windows of her chambers was the specific color of late afternoon turned to early evening, and somewhere behind that light, she was still in the room. I knew. This with the particular certainty of someone who knows where another person is without being told, who has added them to the mental inventory of the world's locations. And the hand that had been braced against the doorframe when I looked back was the most honest thing I had seen all day from a woman who was, professionally, exceptionally honest. Same time tomorrow. Not a question. I put my face into the early evening air and I breathed the specific relief of someone who has been in a pressurized chamber for long enough that ordinary air tastes different. And in the specific location of the small of my back, through the ivory silk and the navy jacket and the evening air, something remained that had the quality of a presence, the memory of warmth, palm flat, fingers spread, the first touch that had been neither accidental nor, on closer inspection, anything other than what it was. The lock had already clicked. I hadn't noticed when,